rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for argument in our case number CV130554, Russell Piccoli versus O'Donnell's. Each side will have 20 minutes in which to argue its position. You'll need to keep track of that time for yourself. The appellants may reserve a portion of that time for rebuttal argument. We've read the briefs and conference this case. We're familiar with the facts and issues presented. Would each of you, as you begin your argument, identify yourself and the party or parties you represent? Counsel for appellants may proceed.
Thank you, Your Honors. Good morning, and may it please the Court. My name is David Gaona, and I represent the appellants Francis O'Donnell, Jr., as well as Kathleen M. O'Donnell in her capacity as the trustee. The appellants are here today appealing the summary judgment granted by the trial court in this case based on a summary judgment that purports to declare that marital assets can be are liable for the payment of marital debts, and if given an opportunity, the Missouri Supreme Court would determine that as a matter of law, marital assets are liable for the payment of marital debt. Given the unique circumstances that exist in this case, that an Arizona court has determined that there's some marital interest in trust assets in this case, and therefore a court can make these sort of decisions before the Missouri Dissolution Court issues its final orders in a pending Missouri dissolution action.
But now, after this judgment, your clients tried to get the Missouri court to sort of quash what Arizona was doing, and they didn't do that.
Well, what happened, Your Honor, is that after the trial court issued its orders, one of the principles or one of the things that the trial court said was that all this can happen subject to further order of the Missouri Divorce Court. The question was, what does that mean? Dr. O'Donnell, in the Missouri dissolution action, did file a declaratory judgment asking the court to weigh in on the issue of whether what the Arizona court did was appropriate or not. Katie O'Donnell filed a responsive opposition saying that's a collateral attack on the Arizona judgment. Judge Essner, the Missouri Dissolution Court judge, in his order said, I don't believe, consistent with Dr. O'Donnell's statement, that the court invited the Missouri court to do something. I don't believe it did by saying subject to Missouri Dissolution Court orders. Therefore, I believe that it is an improper collateral attack, and I'm not going to do anything about it. Judge Essner did not say that the actions of the trial court in those circumstances were appropriate or not. All he said was... It would have been an
opportunity to do so, wouldn't it?
I'm sorry?
It would have been an opportunity for the Missouri court to do that.
Well, it would have been. But what Judge Essner said, right or wrong, is it's a collateral attack, and I'm not going to touch it. In this case, part of our position here is that what has gone on at the trial court below doesn't respect the judgments already in place, and indeed constitute collateral attacks relative to judgments in place, and the appropriate jurisdiction, the exclusive jurisdiction of the Missouri Divorce Court to make declarations concerning what is marital property, what is marital debt, and allocate those particular principles consistent with the factors contained in the Missouri Revised Statutes 452.330 in dealing with those issues. That is exclusively retained by the Missouri Dissolution Court. And in fact, I believe this court, in the underlying memorandum decision that affirmed Judge Donahoe's declaratory judgment, made that clear. This court said on 2, if not 3 occasions in its memorandum decision that Judge Donahoe did not cross that jurisdictional boundary that was created when the Missouri court bought into the notion that the Judge Donahoe could make some decisions limited to whether there were marital interests in the trust assets. Judge Donahoe did not define what the marital property was. Judge Donahoe did not try to allocate the marital property. Judge Donahoe did not try to get involved in marital debt issues. The court, I believe, found that to be important, that that jurisdictional boundary line was not crossed, and it left it to the Missouri Dissolution Court to make those decisions, again, consistent with the statutes in Missouri, which make it clear that for purposes only of Missouri dissolution actions, it is appropriate for a Missouri Dissolution Court to make those decisions and no one else. There are no substantive rights that are conferred upon third-party creditors by virtue of the Missouri statutes dealing with Missouri Dissolution Court actions solely. And that's effectively what's been done here. The third-party creditor here has seized upon what Judge Donahoe said and convinced the trial court that he has third-party creditor rights that exist, which allow him to go execute against trust assets or other resources of the appellants. But what do we know about whether he does have rights? Certainly, a debtor can have no greater rights, certainly a creditor can have no greater rights than the debtor. In this case, it was confirmed by this court in the underlying proceedings and in the underlying memorandum decision that Katie, although Judge Donahoe has determined that there are marital interests in the trust assets, Katie doesn't have an interest in trust assets unless and until the Missouri Dissolution Court determines that she has a present enforceable ownership interest.
But doesn't that principle of Missouri law that neither spouse has a presently identifiable or enforceable interest in marital property, that only regulates the relation between Frank and Katie. Frank can't claim any particular asset as against Katie. Katie can't claim a particular asset as against Frank. But it's basically irrelevant to the question of the rights of a judgment creditor who has judgments against both Frank and Katie. What difference does it make who owns what when they both own it and the judgments are against each of them?
Because it's, first of all, it's a trust asset that is owned by the trust.
Didn't we sort of take it out of that trust in the memorandum decision?
I don't believe so, Your Honor, because I think this court acknowledged and concluded that the only person or the only entity that can do that is the marital dissolution court in Missouri that had pending jurisdiction over the marital dissolution.
Wasn't our determination that the whole action of putting those assets into the trust constituted a fraud on the marriage? Wasn't that what we affirmed?
You did affirm that, but that does not mean that all of the trust assets are open in effect to any creditor of either spouse, because it's only incumbent upon the Missouri Dissolution Court to make determinations of what is in fact marital property, what is in fact marital debt, and how those are going to be allocated equitably for purposes of allowing a creditor to determine what he or she can do as well as the property that the spouses hold. Because until that happens, it's tenancy by the entirety type property. But again, trust property is not that. Yes, Your Honor, I apologize.
Sorry. How would your client have this play out otherwise? How would this debt be satisfied?
I think the debt has to be satisfied like any other creditor debt has to be satisfied. And I believe we cited, Your Honor, to some cases in Missouri relating to debt. One particular case that we cited, Your Honor, to is the Williams v. Frisbee, Your Honors, to was the Williams v. Frisbee case. And in that case, the court made it clear that as it relates to debt, and I apologize, let me find that right away. That case said that a creditor of a beneficiary to a trust cannot, in fact, garnish wages from the trust until there's been a distribution made.
Well, here though we have a creditor, both Katie and that there are judgments against Katie and Frank, and there's an Arizona judgment that says that those judgments may be satisfied from from the marital property as determined by the Arizona court. In that particular case, I mean, just kind of spin this out. How would you, as a matter of fact, expect this to play out?
I would expect it to play out that once the Missouri Dissolution Court makes its determinations as to whether Katie has an enforceable interest in the trust, including whether Dr. O'Donnell has an enforceable ownership interest in the trust, then any creditor has to abide by those decisions.
Well,
that's how it would play out in real life.
And then sue, and then bring lawsuits against them separately to satisfy the judgment or part of the judgment from their own, from the assets that each of them emerge from the dissolution with?
Yes, because until that time, we submit, neither of them have an ownership interest in those trust assets that Judge Donahoe did confirm include marital interests.
Wouldn't you agree, though, that there's a concept of marital assets, and certainly you must in the dissolution, and why can't a marital debt be satisfied from the marital assets?
Because the concept that you just described, marital asset, or the concept of marital debt, only arises by virtue of the Missouri Dissolution Court issuing its decree. Until that time, those concepts don't exist. But
the marital property exists, right?
The marital property exists once somebody files for divorce. Right. And then it's incumbent upon, as this court said, the presumption then takes place. The presumption is that everything acquired during the marriage, leading up to the decree, by the way, is marital property that can be divided, inclusive of marital debt. But the statutory framework in Missouri says those issues and those definitions and those sort of things are only decided by the Marital Dissolution Court. So there is no substantive right that's been conferred that any creditor can jump on the bandwagon and pursue.
But didn't the Missouri court solicit the Arizona court's determination of this marital property?
It did, and Judge Donahoe, in fact, took that solicitation and ran with it. But there, in effect, what happened in the underlying proceedings is the Missouri Dissolution Court conferred that factual finding to Judge Donahoe, but said, I still want to be able to do my job, and that's determine all marital property and all marital debt and allocate accordingly. So the role of Judge Donahoe in this situation, given the unique procedural situation that was going on between the trust administration action pending in Arizona versus the dissolution action in Missouri, made it expedient at the time for Judge Donahoe to pursue further the factual inquiry about whether marital assets are within the trust. And that was all agreed upon by the Missouri Dissolution Court. So in essence, the Missouri Dissolution Court conferred limited factual findings to Judge Donahoe, but retained its exclusive jurisdiction to make those other decisions.
Is the Williams case you cited, is that your best case for the proposition that the law doesn't allow a creditor of the couple to execute against the marital property?
No, I can't say it's my best case, but here's what I can tell you. And the whole argument being made here is there's no law, and so we look to other law out there, and there's this self-coined American rule. There is no self-coined American rule, but the bottom line is in Missouri there is law, and that's called the statutes. And the statutes clearly define what occurs in this situation as it relates to the Missouri Dissolution Court doing its job. The statutes don't confer a substantive right on third-party creditors. The statutes make clear that for purposes of dissolution actions only, it uses that word, these are the things that the Missouri Dissolution Court can do. And in the absence of that, the rights of the parties retain what equitable distribution states provide, and that's tenancy by the entirety and contract rights that might otherwise exist until the decree is issued.
If the creditor here was able to execute against the assets of the trust as they have been characterized by the Arizona court as marital property, that wouldn't interfere with the ability, with the power of the divorce court to do equity in the end with the property that remains, right?
I can't disagree with that, Your Honor, because it is incumbent upon the Missouri court to do equity and take into account everything, including whether some marital debt that it is characterized was captured prior to that decree. I agree with that. However, we've cited, Your Honor, to the Pickering case. And the Pickering case in Missouri says, unless an asset or a debt is part of what the court can look at the time of the decree, it cannot be considered in an allocation. Now, that's what the Pickering case says, but I agree with you that equitably the court can look at that and take it into account for purposes of dissipation, things like that 452.330 identify as factors. But that's exactly what the Arizona court didn't do. It said this is a marital debt, but didn't take into account the factors established by Missouri on what you take into account when looking at debt and how you will allocate or award that debt to either spouse.
But the Arizona court in this case didn't purport to be making an equitable apportionment of property like the divorce court would. It just said Piccoli's got judgments against both Frank and Katie, and we've already identified property that belongs to both of them.
Your Honor, if I may for 1 minute take a step back before I respond to that question, and it goes back to the judgment against Frank and Katie. What we have here is a declaratory judgment that is improper from the get-go on due process grounds. And we've cited, Your Honors, to Heinig v. Hudman, which is a case very similar to this, where the arbitration went forward in the underlying proceedings. It was only against Party 1 versus Party 2. Party 2 was married, but wasn't part of the underlying arbitration agreement that led to the arbitration, so the spouse wasn't joined. Party 1 gets a judgment against Party 2, and then goes to Superior Court and confirms it, as is allowed, got it confirmed, and then instituted a declaratory judgment against the spouse who wasn't part of the arbitration. And the court said, in that case, that was the wrong thing to do, because the spouse who was not at the arbitration should have a full and fair opportunity to litigate issues of debt being applied against him or her.
Right, and we understand you have a separate argument about the propriety of these judgments. But then, assuming that the judgments are valid, then that's the point that we're discussing right now.
What I'm discussing, and I apologize, I would like to reserve at least 3 minutes here, and I apologize for saying that, but as it relates to your question, assuming that to be true, doesn't it make certainly more sense to allow the Missouri Dissolution Court to operate on a clean slate with everything and make an appropriate division, rather than allow either this jurisdiction or other jurisdictions to piecemeal some of these issues that are really within the exclusive jurisdiction of the Missouri court and make them subject to what the Missouri court does, making or potentially invalidating everything that's occurred. We have in place the dissolution action that should be respected.
So if I understand your bottom line, it is that a judgment creditor, a creditor with a judgment against both parties, has to wait, let that judgment sit, can't collect it against marital property, has to let it sit, earning interest, I assume.
Like every judgment.
Like every judgment, until such time as the dissolution court ultimately makes the allocations.
Yes.
Okay.
Thank you. I'll reserve the rest of my time. Thank you.
Good morning, Your Honors. Russell Piccoli, appearing for Russell Piccoli, PLC. May it please the Court. I think we start on common ground today. This is a very, very unique situation that's never arisen under Missouri law, and it's likely never to arise in the future because of the unique procedural background of this case, which I know you're familiar with because you've been there.
Except that it would seem to me to be of ongoing interest what the nature of marital property in a marital property estate, in a marital property state, is what's the nature of that as opposed to third-party creditor claims. That issue could arise. We have this strange procedural thing here between Arizona and Missouri, but it would seem to me an ongoing question, what does a creditor do with regard to marital property? And what's most interesting in this case is that if you want to call it the marital debt that you now basically own, arose after the petition for dissolution was filed.
Absolutely. The reason why this case is unique is because in the normal Missouri case, marital property is created by the divorce court at the same time as marital debts are allocated. It all happens at once. Because of the unique procedural background of this case, and because and you know the background, I'm not going to tell you, but the Arizona court resolves what is at least a good bulk of the marital property. Now, 3.5 years ago, in a divorce that's now been pending for 6.5 years with no trial date set. I don't know. The situation has never arisen previously under Missouri law, and given how Missouri law functions under its dissolution statutes, I'm guessing it's not going to arise again, but I can't peer into the future. But obviously, Judge, you're absolutely correct. Yeah, the issue of whether a marital creditor can execute against marital property could arise, but that issue will arise in the instance at the instant in time where the Missouri divorce court says this is marital property, these are the marital debts. That's what's going to arise at that instance in time. And I cited the Locke case 2 days ago. We found it as a supplemental authority. And indeed, in the Locke case, the mother...
What's that name?
Locke, L-O-C-K-E. It was cited on Monday, and I apologize. It came in by supplemental authority on Monday, Your Honor. And if I go off the top of my head, it's 901 Southwest 2nd, 912. The pertinent language is at 916, and I assume somebody's writing that in the back. But in any event, in that instance, the intervener, husband's mother, got a judgment against the wife. I mean, it happened in the divorce, but it happened all at that instant in time. But I do think it's unique in the way this came up. And because it's unique, I mean, Judge Cooper looked at the situation. I mean, we got a unique situation. How would a Missouri court act? Well, there were certain building blocks to her reasoning. One is when there's unsettled questions of Missouri law, a Missouri court looks at the law of other states. It looks even at community property states under Moore versus Moore. And she looked to see what have other states done with this issue. Now, Arizona is easy. You're all familiar with Arizona law. A community debt can be executed against community property. I mean, it's basic, it's fundamental to our understanding. And other states follow it the same way. So she started there. She looked at Missouri partnership law. Missouri partnership law, listen, partnership debts can be executed against partnership assets. But I think she also looked at the underlying equities over here. There's, under Missouri law, and it's a little bit different than Arizona law, either spouse can contract a marital debt on their own, outside the control of the other. And that's a little bit different over here with the cases that David brought up under Arizona law. Listen, if there's an action, the other spouse needs to be joined. But Missouri is a little bit different in that respect, in that one spouse can create the debt outside of the control. Now, the divorce court later on can look at who created the debt and allocate it as it thinks proper, in the way it should. But insofar as the existence of the debt is a marital debt, there is a long line of Missouri case law going back to Welsh and carrying through before and after to the amendment of the dissolution statute, which says, hey, marital debt, either spouse. I mean, the husband can't go. I mean, I know you want to say something, so I'm going to stop.
I just want to ask, and that's true as to any debt incurred, or that's true as to a debt incurred after the filing of the petition, but prior to the dissolution decree.
Correct, because Missouri also differs in Arizona law. It's during the course of the marriage.
Right.
But under Missouri law, a few years ago, and I can't remember, 1998, you may remember better than I, when the law changed in Arizona, when the community would terminate. It used to be the community would exist all the way through until the time of dissolution. But in 98, we changed. The community terminates at the time of service on the defendant spouse, if you will. Missouri's different. Another unique thing, I mean, Frank O'Donnell's still working for Katie over here 6.5 years after filing. But that's different under Missouri law.
Okay, so that helps your argument that a debt incurred by Katie to enforce the marital assets, I mean, separate and apart from the equities of where that debt ought to belong.
Absolutely, it helps because of the argument. Because normally we would have to join Frank in the underlying arbitration if this were Arizona, but in Missouri we don't have to do that because it's the marital that's there. Neither spouse can challenge that type of thing. But in getting to the basic equities, she looked at, the judge Cooper looked at with property. I mean, we created this property. Prior to the decision that was affirmed by this court, this wasn't marital property. They were claiming it was all Frank's. Katie had no interest in it whatsoever. We brought it in. Katie incurred that debt, paying us to create this marital property. Now, I think, or at least I'll argue, lawyers deserve to be paid. And what's unfair about having a lawyer be paid out of the fund they have, essentially created? We apply that concept in other areas of law, the common fund doctrine. It's a little bit different here, obviously, but that was the basic, the basic rule. And then we get back to Missouri.
I doubt that we're going to decide your claim based on what we think is fair to you, that based on we think you ought to get paid or we don't think you ought to get paid. We're going to decide what the law requires.
And listen,
you have a judgment, and so the question is, can you execute it?
But I want to go back to something you started with, Judge Thompson. And listen, the Missouri court, the Judge Cooper's declaratory judgment was made expressly subject to his further order. Wanted to give deference to the other court. I mean, these two courts have been kind of working together the whole time, as you people are aware of. And we wanted to do the same thing here. And it went back. Frank, approached the Missouri divorce judge, said, hey, throw this thing out. Katie opposed it. Missouri judge refused to touch it. We need to reasonably assume that if the Missouri divorce judge, Judge Esther, thought, hey, this is going to really interfere with my allocation of the marital property and the marital debts, he would have done something. We likewise have to assume that an experienced Missouri judge, if he sees, hey, listen, this is out of whack with Missouri law, he's going to do something. He did not. So we're here today with a declaratory judgment that I believe comports with American law, that I believe does not run afoul of Missouri law in any fashion, and it's supported here and there, obviously, by bits and pieces. And I'll say it again, although you're not going to resolve it on basis of fairness, but it's fair. It's right. And if Frank has some argument later on in the day, if he wants to argue to the Missouri divorce judge, listen, Katie ought to bear the cost of unraveling my fraud, he's free to make that argument. Judge Estner can say yes, Judge Estner can say no, but that's up to Judge Estner at the time of the final decree. But in any case, unless someone has another question for me, I'll sit down and give it to David. Thank you so much, Your Honors.
Thank you. With respect to some of the questions that have come up, I wanted to begin by saying in King v. Altman, another case we cited, that very clearly stated that an in personam judgment may be rendered against one who has never been a party to litigation would seem so obvious that citation to authority would be unnecessary. The underlying judgment we're talking about that was issued by Judge Cooper is a result of an arbitration that these appellants were not parties to. Fundamentally, the judgment is flawed in that regard.
But is it different in that the arbitration involved Katie's efforts to augment the marital property? That is, you've got cases where one spouse incurs a debt, presumably for that spouse's own benefit, and you can't generally bind the other spouse. But here, so I guess I'm talking about the Sigmund case in Arizona.
Okay.
Right? Our case.
Right.
But isn't it different when it's been determined that what Katie established with the Arizona proceedings incurring an obligation to Piccoli was basically to benefit the marriage and augment the marital property.
No.
And does that make it different?
No, I don't think so. And it doesn't make a difference because in the arbitration proceedings, what are we talking about? We're talking about one party's claim against another for money. It doesn't matter what the underlying basis for that money is. I suspect that most people in arbitration are saying, gee, it's fair that I get this money. And therefore, in arbitration, I'm going to hold them to their obligation and ask the arbitrator, because we have an agreement that says you have to go to arbitration, ask the arbitrator to award me that amount of money. Only people that are subject to that agreement are appropriate parties in the arbitration proceedings. Dr. O'Donnell was not subject to that agreement. It was a fee agreement entered into by Katie solely on her own behalf to deal with her issues as a result of the divorce. And I agree with that part of it, Your Honor. But it wasn't an agreement that allowed Frank to be a part of the arbitration. And so the Arizona law is clear. If you're not part of the arbitration, it is inappropriate to apply that against a non-party. So what did Heinig and Hudman do? Filed a declaratory judgment action. They said, no, you got to file an action for monetary damages to make sure that the party who was not in the arbitration to exercise full and complete rights to litigate all the issues has a chance to do that.
But Frank was allowed to contest the arbitration award.
Frank was allowed
for collusion and for other things.
Frank, once that was filed, we asked for a stay initially, as I think Your Honor knows, by virtue of the record. And then when that wasn't granted, we asked for some discovery. Judge Cooper allowed us 60 days of discovery to deal with the confirmation issues, but not to deal with the marital debt issue and whether that was within the purview of Missouri law. I submit to you, Your Honor, that giving us limited time, 60 days, to conduct discovery was not adequate. And as it relates to the limited discovery that we were entitled to engage, we did. And what did that show? It showed email communications between the two attorneys relative to the arbitration. It showed Katie's deposition testimony on what she thought she was doing when she stipulated to the judgment. It shows we submit material facts, the inferences of which must be resolved in our favor, that suggest collusion or undue influence was practiced, and therefore the confirmation should not have occurred relative to that particular award. So that's what we would submit, Your Honor. I know I'm out of time. Unless Your Honors have any other questions, we would ask that the underlying judgment be vacated and remanded back to the court with instructions that the matter be stayed until the Missouri Dissolution Court takes action, and to the extent any further action is to be taken, that it's a monetary claim against the appellants as opposed to a declaratory judgment claim. Thank you.
Thank you, counsel, for your arguments. We'll take the matter under advisement. We'll issue our decision in due course. We'll be at recess.